Test, can you hear me?
I can hear you.
Good, thank you. I do not know if there's a way to pause recording, so
That's a good question.
I mean, it's okay. It starts in 15 minutes anyhow. I am also going to make sure that my voice recorder is on. Pause for a moment. I'm going to make sure the front desk knows if anybody, I don't think anyone will come here, but them to know, let us know. I don't think anyone's going to come. So stand by. I'll be right back.
Okay.
Joy and I went over there and we played a blast. There's your table.
That's an awesome standing desk.
Yeah, I built this. Really? The meeting has started. Marty's co-hosting. Marty, do you have the ability to share screen?
I do.
Why don't you try that and go to our oil and gas website, and I'll tell you what it is if you don't have it bookmarked. And I can do this also, by the way.
Okay, I'm at the oil and gas website.
Yeah, good memories, huh? Go down where it says meeting and hearing at the top ribbon and click on administrative hearing.
Okay.
And select docket 2023, the one at the bottom, 01001.
Got it.
And most likely the document that folks will be referencing is going to be the it's probably going to be the application back from January 2023. See where it says application for integration?
Yeah.
So that's a robust document with 161 pages. As Mr. Christian and Mr. Piotrowski speak, they may refer to this. And if they need you to find something, you can come on, you can unmute and say, Mr. Hearing Officer, could you please ask the witness to indicate the page number that he's to? you feel it out, right? If they ask to share it and they're referring to it, you can do that, or I will. More than likely, I will, and then I'll just say, Marty, can you pull up this page? Is
Okay.
that okay? You got that?
Yeah.
All right, good, very good. Do we have so Hayden has come into my office. He's our counsel. Do we have anyone else in the waiting room that you know of?
No, I can't see anybody.
Not to interrupt, man.
Go ahead, Hayden. But hey, by the way, we are recording, so I can mute if you'd like.
Sure, no, I'm just, if I want to log on to a Wi-Fi, is there a password?
It should say. Yeah. Username, email, password. See if it's
Just so you know, when you step away from the camera, I can't hear anything you say.
that's kind of the plan.
Okay. Cool.
Okay.
Cool. Mike Christian is waiting in the lobby.
Thanks. Let's not let him in yet. I want Hayden to come back and we'll shut the door. Thank you.
Okay.
All right, Marty, you can let him in. James, it's good to see you.
Good morning.
Morning, Mr. Christian.
Good morning. It is asking me to admit Mr. Piotrowski.
Oh,
If you have that ability, please do so.
Right.
Thank you. Good morning, Mr. Piotrowski. How are you?
I'm doing well, thank you.
Thank you for your flexibility and coming back to this rehearing. Let's wait a little bit, see if anyone else comes in. For everyone currently on, I have not started the hearing yet, but the meeting is being recorded, just as a heads up. I do have the blinking recording button, and I've asked one of our staff, Marty Mensinger, to make sure it's recorded this time. And I have a definite secondary recording device, and so you all are very gracious for reliving this again. Thank you. I will ask before we start, Mr. Piotrowski, do you anticipate any additional people that you know of joining this hearing today?
No,
Thank you. Mr. Christian?
Mr. Brown will join shortly if he's, I assume he'll be here in a minute.
Thank you. Mr. Thumb, is your counsel going to attend?
Mr. Hearing Officer, I just texted her a few minutes ago and she said yes.
Okay, thank you.
I do have an update. I think she was like me. She couldn't find the Teams invite and she just found it. So it may be a second before she joins us.
Thank you. Thank you a ton. I know it was updated this morning, so we'll wait a little bit. If anyone, Mr. Christian and Mr. Brown has a problem, also please do what you can to get them plugged in.
I seem to be the one with the power to admit people. Not sure why.
Is that external number that's on, is that Mr. Brown?
I don't know.
Okay.
I've texted him, Mr. Administrator. I'll see whether I can find out his status.
Thank you.
Mr. Administrator, Mr. Brown is trying, but having some challenges. I'm working on him right now.
Thank you, Mr. Christian. Is the number with the 707-1227, would you please identify yourself?
Of course, this is Joanne Higby.
Thank you, Joanne. I did assume it was a Payette number, Payette County number because of the 707, but I'm glad to have you today. Thank you.
Thank you.
Mr. Christian, I'm going to go ahead and start the hearing. If Mr. Brown needs to, if he cannot get the link going, perhaps he could call your phone and have and put it on speakerphone. Maybe that's an option.
Yes.
Okay.
I'm just texting him that option. I've given him the information that should allow him to log in.
Okay. Well, I appreciate you working through that. I'm going to hit the secondary recording device now.
Oh, wait a minute. Richard, is that you? I believe that's Mr. Brown who has joined.
Yeah, I joined by phone.
There we go.
All right, we're going to go ahead and start. Thank you. We're now on the record in docket number CC2023OGR01001. It is now 9 a.m., 9:06 a.m., Tuesday, October 24th, 2023. We're at the Idaho Department of Lands in Boise, Idaho. This is the time set for the evidentiary hearing as provided in Idaho Code 473283 for the spacing unit consisting of Section 24, Township 8 North, Range 5 West, Boise Meridian, Payette County, Idaho. My name is Mick Thomas. I am the Minerals, Navigable Waters, and Oil and Gas Division Administrator, presiding over and conducting the hearing today pursuant to Idaho Code 47328. There is some housekeeping. This hearing has an in-person component, but everyone has chosen to participate virtually, which is fine, via Teams. That allows participants to, of course, attend remotely. The hearing is being recorded in Teams. I have double-checked that. As required in IDAPA 0411011651. I also have a backup recording device, which I have also verified, that is recording this hearing. Because the hearing is being recorded, I ask everyone here to be sure to speak loudly and clearly. Please limit side conversations. And if you haven't done so already, silence yourself. For those of you on Teams, there's also a mute button that looks like a microphone in the upper right-hand corner. I recommend you make sure that is muted unless you are speaking. Thank you. If there is a disturbance, you will be reminded to mute your microphone. If the disturbance continues, you may be muted and or disconnected by myself or assistant, Marty Mensinger. For those attending in person, come to the podium. There are none. Documents in the record, docket number CC2023OGR01001 are on the OGCC website at ogcc.idaho.gov/administrative hearings. Exhibits and witness list were submitted by Wednesday, August 23rd at 5 p.m. And all participants in the pre-hearing conference have received those. For these observing the hearing, the exhibits are posted on the OGCC website. During the hearing, participants can ensure that we are all looking at the same document by referencing the exhibit number and the page number by the PDF page number. If an exhibit needs to be displayed on our Teams platform, please direct us to each specific exhibit and page you would like displayed so we can screen share that exhibit. As my July 27th, 2023 notice of evidentiary hearing indicates, this hearing is to receive evidentiary and evidence and testimony regarding Snake River's January 23rd, 2023 integration application. I will use the factors articulated in my order determining just and reasonable factors to determine whether the terms of an integration order fulfill the just and reasonable requirements of Idaho Code 47320 sub 1. The order determining just and reasonable factors was mailed to the operator and all uncommitted owners in the spacing unit on April 13th, 2023. It can also be found on the OGCC website. We'll proceed with opening statements from Snake River Oil and Gas, uncommitted owners within the unit, then the IDL. The opening comments will be limited to 5 minutes. After the opening statement, the hearing will proceed as follows. I'll first hear evidence from the applicant, Snake River. This will be followed by evidence from non-consenting owners represented by Mr. Piotrowski. Afterward, I will accept evidence from the Idaho Department of Lands. After the presentation of evidence is complete, I will allow closing arguments. I will provide recesses from time to time as needed. And I would like for anyone who speaks to state your name for the record. If you are here as a representative, please indicate your own name as well as who you are representing. I may ask clarifying questions while you speak. Now for appearances. Mr. Christian, will you please identify yourself and who you represent for the record.
Thank you, Mr. Administrator. Michael Christian. I'm here for the applicant Snake River Oil and Gas.
Thank you. Mr. Piotrowski, can you please identify yourself and who you represent?
James Piotrowski of Piotrowski Durand, representing Juanita Lopez, Sarah Weatherspoon, David George, Gary Hale, Ryan Gentry, Mark Vidlac, Mark and Melanie Mullins, Jessica and Andrew Ogburn, Yvonne Smith, and Richard Lancaster.
Thank you. Ms. Winters, can you please identify yourself and who you represent?
Good morning, JJ Winters with the Idaho Office of the Attorney General. I represent the Idaho Department of Lands, and I'm here with Mr. James Thumb. Well, he's in his own office. He's with the Division of Minerals, Navigable Waters, and Oil and Gas with the Department of Lands.
Thank you, JJ. Are there other uncommitted mineral interest owners in the proposed unit that plan to participate today? All right, hearing none, we'll move on to opening statements. I'll now give each party the opportunity to make an opening statement. Please remember your statement is limited to 5 minutes. Mr. Christian, as a representative for the applicant, you go first.
Thank you, Mr. Administrator. As I think I stated the first time we tried to do this back in September, I believe the application of January 23rd, 2023, and the affidavits, or declarations and exhibits attached to it sufficiently address the just and reasonable factors and the statutory elements required for an order integrating mineral interests in the spacing unit, and are sufficient, more than sufficient, to support the order requested. The application itself, which was resubmitted as Exhibit SR1, the application and its supporting materials, and the affidavits of publication and mailing from post filing, which was submitted as Exhibit SR4, was also submitted and is already part of the record. I think all I need to do this morning, sir, is put on some additional testimony regarding Exhibits SR2 and SR3, which are the updated map and track map. And I intend to call Mr. Brown for that purpose. That's all I have.
Thank you, Mr. Christian. Mr. Piotrowski, would you like to make an opening statement?
Sure. Determining just and reasonable terms for compelled leasing is impossible unless you know the market. And you don't know the market, Mr. Thomas. The only market we're going to have evidence about is the one created by Snake River Oil and Gas for its own benefit. I asked for the opportunity to challenge whether or not, in fact, a 1/8 royalty was a market-based royalty, but you denied my motion for subpoenas. So I can't get the evidence, which is only in the possession of Snake River Oil and Gas, to show the market rate for such leases. I asked for the evidence to show what would be the appropriate royalty. You denied that subpoena. You are continuing to prevail, or preside rather, over a process that is based solely and entirely on the integrity of known liars, mainly in the oil and gas industry. Every attempt by me and my clients to challenge the system to show that, in fact, the terms are not just and reasonable, that, in fact, maybe the leases weren't entered, is avoided, denied, prevented by the Oil and Gas Commission, its regulations, and the statutes creating it. We know, in this case, that Snake River Oil and Gas has leased at $150 per acre, at 5/30 seconds royalty, or perhaps more, with no right to surface access, and on gross instead of net. We know that because one former non-consenting owner entered such a lease. And yet, Mr. Christian will be here telling you that the just and reasonable market rate is far, far less than that, with no evidence other than the unsworn testimony of Richard Brown, who will tell you, we signed a bunch of leases, we gave them to James Thumb, and we're done. That is not justice. That is not reasonable. That does not comply with due process of law. And although I fully expect you to rubber stamp this integration application, you shouldn't. Thank you.
Thank you, Mr. Piotrowski. Mr. Thumb or Ms. Winters, do you have opening statements at this time?
No opening statement from the state, Mr. Hearing Officer. We look forward to having a civil hearing today, and would like to remind everybody that
Excuse me, I will not be reminded or scolded by an deputy attorney general.
Mr. Piotrowski and Ms. Winters, thank you for your comments today. I am the hearing officer, and I will monitor the hearing as we move forward and make sure that everyone is civil and respectful to one another. Okay,
Mr. Thomas.
Mr.
thank you.
Piotrowski
That's our
and Ms. Winters, please. These were just opening statements. We'll go through the hearing. Let's move forward.
Mr. Thomas, I have a
there-
motion to make.
no further statement.
Thank you,
At the
Mr.
appropriate
Winters.
time, Mr. Thomas, I have a motion to raise.
Thank you, Mr. Piotrowski. I'll get right back to you. Are there any other opening statements from any other uncommitted owners? Or at this time? Okay, Mr. Piotrowski, you have a motion to make. Please go forward.
Mr. Thomas, I move that you, in your role as the presiding officer of this hearing, and in your role as the client of a deputy attorney general, order the disclosure of all communications between Ms. Winters and anyone else in the Idaho Department of Lands that reflects or relates in any way to this application. I believe that the deputy AGs who are representing different parties in this process are engaged in ex parte communications that may affect your decision in this case. To address that, to determine whether that's true, and if so, to fashion appropriate remedies, I ask that you order the deputy AG representing you to disclose all communications she has had with J.J. Winters that relates in any way to this case. These are not privileged communications, by the way, as they're between attorneys representing different parties.
Thank you, Mr. Piotrowski. In light of that motion, I'm going to move into a brief, let's say 5-minute recess. The recording will continue. I'm simply going to mute my mic and talk to counsel in light of that motion. Thank you, Mr. Piotrowski. Ladies and gentlemen, thank you for your patience. I know that went more than 5 minutes, but there was a number of things we had to discuss. First, Mr. Piotrowski, I don't have any indication on my end of any ex parte communication. That said, I am going to grant your motion with some direction. I'm going to leave the record open so that we can continue today's hearing. And I'm going to ask you, Mr. Piotrowski and counsels, a couple of things. One, Mr. Piotrowski, if you would draft and submit declaration that I can add into the record describing why you made this motion and the grounds supporting it. And I would also like to have other counsel submit a description of any communication you've had with other parties. Now, as a hearing officer, I'm not a party. My counsel is not attorney to party, but you're welcome to share any communication you've had with my counsel, Hayden or Joy Vega. So that's my decision on the motion. I am asking that all of these requests be provided to me by the end of the day, Thursday, October 26th. Thank you. Now, back on track. We got through opening statements. And as far as evidence, I'm now going to invite Snake River to provide testimony and call its first witness.
Thank you, Mr. Administrator. I would call Richard Brown.
Mr. Brown, do you swear or affirm that the testimony you will give at this hearing is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Christian. You may proceed.
Thank you, Mr. Administrator. Richard, you are a partner in Weiser Brown Oil Company, is that correct?
Correct.
And it is, Weiser Brown Oil Company is the sole member of Snake River Oil and Gas LLC, which is the applicant here?
Yes.
Okay. Are you responsible for managing the day-to-day operations of Snake River, including its leasing and permitting efforts?
Yes.
Are you familiar with the application materials and exhibits filed in this matter?
Yes.
Okay. Since the time of the application was filed in January of 2023, the applicant engaged in continued leasing efforts, right?
Correct.
And did manage to lease a number of additional owners in the unit.
Yes.
Okay. Exhibits SR2 and SR3 are the updated map and track list that we filed. Are you familiar with those exhibits?
Yes.
I'm not, Mr. Administrator, I'm not going to have him refer to any particular pages or details on it, so I don't know that you need to bring them up. You're welcome to. Mr. Brown, what is the current percent leased in section 24?
Approximately 88%.
And do exhibits SR2, the updated map, and exhibits SR3, the updated track list, reflect the current state of leasing in the unit?
Yes, they do.
Okay, that's all the questions I have for you, Mr. Brown, and I would offer exhibits SR2 and 3, Mr. Administrator.
Thank you, Mr. Christian. Mr. Piotrowski, you may ask questions of the witness at this time. Mr. Piotrowski, you're currently muted.
Thank you, sir. Mr. Brown, your company is proposing to require non-consenting owners to see their minerals taken at a royalty rate of 1/8 with a $100 per net mineral acre bonus payment, correct?
You said their mineral rights taken?
Well, yeah, you're taking the oil and gas rights for that price, right?
Well, I'm not going to argue with you. Anyway, if it proposed to lease them, yes, correct. Propose them lease at 1/8 and 100 an acre.
Okay. And the basis of you and your colleagues for that proposal is that you say other leases in the area have been entered on those terms, correct?
Ask the question again, please.
Sure. And a substantial part of the basis for your company's position that proposal is just and reasonable is the fact, as set out in affidavits, that and in the exhibits and in your testimony here, that other leases have been entered at 1/8 and $100 bonus payment, right?
Correct.
Okay. How many leases has your company either entered into or been a successor to or purchased? How many leases that have exist out there that Snake River now owns the rights to for more than 1/8 royalty?
One that I'm aware of was taken after the application.
I don't mean in this unit. I mean statewide in Idaho.
Objection relevance.
Sustained on that. It is not relevant, Mr. Piotrowski. Please rephrase the question.
Okay. How many leases has your company either entered into or become a successor to in the Payette River Valley where the royalty rate was greater than 1/8?
Same objection.
I am going to sustain that, Mr. Piotrowski. I respect where you're going with this, but I would ask that you pertain it to the unit, please.
Sir, I don't understand. Your indication of factors indicated that we should look at industry practice. The industry practice extends beyond section 24. But I mean, yeah, I understand your ruling. I'm going to keep asking my questions. You'll keep ruling on them. How many leases has your company entered into in the Payette River Valley that call for a bonus payment greater than $100 per net mineral acre?
Mr. Administrator, I have the same objection. I will note for the record that one of the terms and conditions,
Objection
I'm
to
sorry,
the objection. We're not here to argue. I'm just asking questions.
I'm trying to formulate the objection, Mr. Piotrowski. If you give me a second, I might help you. I would note, Mr. Administrator, that one of your just and reasonable terms is whether the proposed terms and conditions are similar to other agreements within and near the unit. Now, and if a term is not similar, if there's reasons why it's different or should be a different term should be appropriate. I would take in or near the unit to mean reasonably adjoining units.
While Mr. Christian's opinion is what it is, I don't agree with him, not surprisingly.
Wait,
I think the Payette River Valley is near.
Wait just a moment. Mr. Christian, thank you for that explanation, as well as the reference. It enables Mr. Piotrowski to continue with your line of questioning. So please go forward, Mr. Piotrowski, with your questions of the witness.
Mr. Brown, how many times has your company entered into a lease or become a successor to a lease, acquired the rights to a mineral lease in the Payette River Valley that provided for a mineral interest payment greater than $100 per net mineral acre?
Mr. Administrator, I'll add the additional objection that the relevant time frame is at the time of application.
Thank
Can
you.
I get an answer to my question, please?
Piotrowski, I believe you're asking about an area adjacent to this unit within a specific time frame since the application was submitted let's say calendar year 2023.
I can't ask before 2023?
You can. I'm just trying to make sure that I understood where you're going with the question.
Oh, no,
So-
no, I'm asking about historically. I want to know all of the leases that Snake River is a party to in the Payette River Valley that call for greater than 1/8 or greater than $100 per net mineral acre. Those are my questions.
Thank you, Mr. Piotrowski. In the interest of moving forward, I would allow that question to be provided. Mr. Brown, if you can answer that, please do.
Greater than 1/8 and
Or greater, I'm sorry.
the greater than 100 an acre. In the immediate offset area, after this application was filed, we did raise the price per acre to $150 an acre in the effort to avoid integrations. And we took my recollection is we took 3 total leases with royalty greater than 1/8 out of potentially 50 to 100 leases taken.
Okay, and Mr. Brown, it sounds like you're describing what happened in this spacing unit in section 24. Is that right?
Yeah, we were not leasing in other areas.
Okay. Now, every lease SROG or Brown Weezer is a party to in the Payette River Valley that has, how many leases are there total in the whole Payette River Valley? Not this section, not this spacing unit, in the whole valley. How many leases is your company a party to at this point that call for a royalty greater than 1/8?
Mike, I don't think that's relevant or
Mr. Brown, I'll allow the question if you have the answer.
what's that?
If you have the answer, you can answer it.
I can answer it, you said. I don't think the question is relevant. We're in a competitive basin. This is an integration hearing in regard to what competitive terms are, and I don't think those are competitive terms.
Wow. Mr. Thomas, could you please direct him to answer the question?
Mr. Piotrowski, he has given his answer at this time.
That he won't answer the question? You're just going to let him get away with that?
You asked the question, he answered it. That's where we are.
How many leases do you have, Mr. Brown, in the Payette River Valley over 1/8 royalty? How many? Give me a number, please.
I don't know the answer.
Okay. It's more than one, though, isn't it? Is it more than one?
Well, Mr. Piotrowski, you know that there's more than one in section 24. There's about 3.
And I'm not the one that's under oath, and I'm not asking about section 24. Mr. Brown, your company has entered into leases with a royalty rate in the Payette Valley over 1/8, hasn't it?
Mr. Piotrowski, you've already accused me of being a known liar. I'm not going to be badgered by you. I can tell you that.
Well, then maybe you don't get your integration because I'm entitled to ask questions that the hearing officer has told you to answer. How many leases over 1/8?
So, Mr. Brown, I appreciate your passion as well, Mr. Piotrowski. Mr. Brown, if you're able to answer the question, please do. If you're unable to, I will stop this line of questioning and Mr. Piotrowski will go to the next one.
I do not know the number. I have told you that.
Thank you, Mr. Piotrowski. Please move forward.
Thank you. Mr. Brown, we could find out that number by actually reviewing the leases that your companies are a party to, right?
What's the question again?
if we actually looked at all the leases, we could find an answer to that question, couldn't we?
I suppose so.
And your company, whether it's Snake River Oil and Gas or Brown Weezer, you have access to copies of all of those leases to which your companies are a party, right?
Of course we do.
Okay. And you could, if you wanted to, or if you were ordered to, you could produce copies of all of those leases if you had to, right?
Yes, I could.
Okay. And if that occurred, which it hasn't in this case and doesn't appear it's going to in this case, but if that occurred, we'd be able to tell how many leases exist that call for a larger bonus payment than $100 per net acre, right?
What's the question?
If we had those leases, we could figure out how many leases were over 1/8 and how many leases were over 100 per mineral acre. And we could figure out a lot of other things too, like how many of those leases were on gross production and how many were on net production. Those are all answers we could come up with if we simply got those leases together and reviewed them, correct?
I don't believe that that's how the integration process works, but anyway.
I'm just asking if we could do that if we had the paperwork. If you had the paperwork in front of you, all those questions could be answered, couldn't they?
Possibly so.
Okay. What's your expected return on investment for the well in section 24?
There's so many risk factors involved. That's a.
I'm sorry, I was muted, Mr. Administrator. I'm objecting based on relevance.
Mr. Piotrowski, could you please rephrase the question? Honestly, just for the record, I want to make sure I understood the question before I rule on the objection.
Sure. Mr. Brown, do you have an expected return on investment for the well that your company is planning to drill in section 24?
And my objection is relevance, Mr. Administrator.
Thank you. Actually, Mr. Christian, I'm going to deny that objection. I think it is pertaining to this unit, so I'll allow the question to move forward.
The question is, my expected return?
Yes.
Certainly would exceed the cost of drilling and completing the well.
And what is the anticipated cost of drilling and completing the well?
I have not looked at the AFE. Mike, is there an AFE attached to the application? I assume there.
There's not, Richard.
Okay. And I haven't reviewed an AFE in a while, but I would say in the neighborhood of $3.5 to $4 million.
Oh, what's an AFE, Mr. Brown? That's not a term I'm familiar with.
Authorization for expenditure.
Okay. To date, has Snake River Oil and Gas made any call for financial contribution by its working interest participants?
Objection. I don't even know the scope of that question, and it's not relevant anyway.
I'll overrule that. Mr. Piotrowski, you're welcome to rephrase that. Otherwise, the question can stand.
Sure. Mr. Brown, the joint operating agreement calls for the operator to periodically, at the appropriate times, make a demand on the working interest owners to, put up their share of the expenses to advance the project. Has that happened in section 24 yet with your working interest owners on that unit?
No.
What is the best estimate you and your team have been able to come up with for either the volume of gas a well in Section 24 might produce, or expected payments for the gas that might come out of that section?
Objection, relevance.
Overruled. I think it is a pertinent question.
Not only would I consider that confidential, you're asking me for our projected reserves and projected, of course, the price that we would receive for the commodity. That price changes daily. So the pricing is posted. There's futures prices that you can use, but the price changes daily. As to projected reserves, they would have to be sufficient for us to at least recover our cost. But I would, that's confidential information. That's business information. That's like asking anybody else in any other business to release confidential and proprietary information.
Do you know of any other businesses that force people to sell their assets to them?
Let's try. Yeah, I want to make sure that before you move on to another question, Mr. Piotrowski, that I think Mr. Brown has adequately answered that first question. So you're welcome to ask your second or third or fourth. I'm sorry, wherever you are in your line of questioning, please move forward.
So do you have an anticipated volume of gas? Since price changes daily, do you have an anticipated volume in Section 24?
Same objection. It's not part of any element of integration. It's not done in any other state. It's just not relevant.
Oh, yeah, it was Mr. Christian's claim to that effect. I mean, these are reasonable questions.
I can't say, and again, not only as a hearing officer, but as a geologist in a past life, disclosure of volumes is protected as confidential information. And so I am going to sustain that objection and ask you, Mr. Piotrowski, that your line of questions, of course, continues to pertain to integration, but regarding potential volume and sales prices, think about what that says, and that is confidential information. We won't allow that line of questioning moving.
Mr. Brown, I'll ask you then for a hypothetical. Assume, please, for purposes of this question, that I have a client who owns 1 acre in Section 24. Assume further that you are offering them a lease that provides a 1/8 royalty. What do you expect my client is going to receive in royalty payments from the first well that your company has proposed?
Objection calls for speculation.
It's a hypothetical.
It is a hypothetical. I'll allow the question to move forward. Mr. Brown, it's your discretion if you want to answer that, obviously.
Choose not to answer the question. Just there's so many hypotheticals. There's so many variables. I gladly negotiate with any client. If they want to negotiate, I gladly negotiate with them.
Mr. Brown, next question, please.
Mr. Brown, again, I am allowed to ask clarifying questions. Your answer is, because the question is hypothetical, you're unable to give a definitive response, but you are open to negotiating with any client. Is that your answer?
That is correct.
Thank you. Mr. Piotrowski, you can move forward to the next question.
And as part of those negotiations you'd be willing to have, you would consider royalty rates in excess of 1/8, wouldn't you?
Objection. Are we talking about a hypothetical discussion, or are we talking about in or near the unit?
I'm talking about the comment he just made. He's willing to negotiate. And in the course of negotiation, would you consider a royalty in excess of 1/8 for the Payette River Valley and natural gas therein.
I'll allow the question.
When negotiating with folks, I consider all factors.
Okay. Is there some reason that non-consenting owners should be treated less favorably than the people who sign a deal with you before you file an application?
The question was, should
non-consenting owners be treated less favorably than you treat consenting owners?
I don't think they're treated less favorably. They're getting leases for no surface operations, which is a severe haircut on the value of an oil and gas lease.
Okay, let's talk about that for a little bit. You say it's a severe haircut. Can you give me some examples of the price difference between a lease that includes the right of surface use and a lease that doesn't include the right of surface use?
Depending on the lease size, that would depend on the lease size, but the value of the ability to conduct operations on a lease is very valuable. That is one of the primary rights of an oil and gas lease.
Okay. And yet sometimes you have entered into leases greater than, with a royalty greater than 1/8 with no right to surface access, haven't you?
I have.
Okay. And you've done so in the Payette Valley, haven't you?
I did in this unit, the lease that you're talking about. So
I'm not talking about a lease, sir. I'm speaking very generally. You keep reading into my questions things I'm not saying. You have entered into leases in the Payette Valley where the royalty rate was higher than 1/8 and there was no surface access, haven't you?
I'm only aware of one lease. I'm aware of one lease in the Payette Valley that you just stated. We're talking about one lease that you know is in this section. So let's talk about it.
That's the only time you've gone higher than 1/8, or is it the only time you've gone without surface access?
Without surface access, that's correct.
Okay. And so surface access is one of multiple factors that affect the reasonable value of a lease, correct?
Correct.
And the other factors include the size of the tract, the size of the ownership. Is that right?
Correct.
And what are the other factors that you use to evaluate what you think is the reasonable market value of a lease?
There's quite a few.
Okay. I mean, I don't expect you to give me literally every one of them, but can you educate us on what some of those factors are?
Size, price per acre.
I'm sorry, what do you mean price per acre? Can you clarify that for me?
Dollars paid per acre.
Oh, the bonus payment?
Correct.
Okay, what else?
Royalty.
What other factors determine what royalty you're willing to offer?
Proximity to pipelines, basin. There's myriad of factors.
Now, for the non-consenting owners in this section 24, every one of them would receive the exact same lease terms or deemed lease terms if the integration is granted here, right?
They have three choices, as I understand it: to be deemed leased, to participate, or to go non-consent.
Okay. Or okay. And if they are deemed leased, if they don't choose to participate or are, I'm sorry, when you say go non-consent, do you mean, what do you mean by that? Just to clarify. Non-consenting working interest owners or just non-consenting owners?
There's a JOA attached to the,
Right.
and in this case, refresh my memory, Mike, but I believe there's a, is it a 500%, or I can't remember.
300% risk penalty is what you've asked for in this case.
Okay, excuse me, 300. No, it's 500% for my partners. It's 300% for these owners, which obviously they're getting a better deal than my partners. Go ahead.
Yeah. Okay. So for somebody who doesn't want to be a working interest of any, an owner of any type, who doesn't want to participate in the well in that way at all, if this integration is granted, every one of those people who doesn't choose to participate will be subject to the same terms, which will be, among other things, a 1/8 royalty, a $100 per acre bonus payment, and some other terms that you've laid out, right?
Correct.
And that won't vary based on the size of the property owned by any of those individuals, will it? In other words, they're going to get the same deal if they own an acre or if they own 40 acres, right?
Yeah, well, I think, yeah, that is correct.
Okay.
Clarifying
And-
question, Kowski, I apologize. Are you talking about the same deal on a per acre basis? Was that what you were inferring?
Yeah.
Okay, thank
Yes,
you.
it was.
Thank you. Go ahead.
But the rates, the royalty rate
And out of, I can't remember, but the largest tract owned by any of your clients is how many acres?
I'm not here to, I don't recall it. I'm not here to testify about that.
Okay,
The point is,
I think it's less than an acre and a half, is my recollection.
and in every integration case your company has done in the state of Idaho, you have offered those same terms, basically 1/8 and $100 per net mineral acre to every non-consenting owner in one of these integration cases, right?
And that's not correct.
Oh, who have you offered more than 1/8 to?
No, the terms, the per acre, the dollar per acre has been different in almost every application, depending on the ongoing, what's your competitive terms in the section. That's how integration works in all of the states in the United States that we have integration statutes. I think it's about 35. This is how it works in all 35 other states.
Okay, and so bonus payments have been $100 or $150 per net mineral acre in the Payette Valley, right?
Incorrect.
When have they exceeded 150 per hour or per acre?
They've never exceeded 150. They've been significantly less in many other sections that we've integrated.
You've integrated other sections at less than $100 per net acre?
Correct.
Which ones? I'm going to look at those. Which
I don't have that list in front of me, but anyway, the most recent application was the first at 100 of any we've had.
This is the first time you're saying that Snake
No,
River Oil and Gas has offered $100 per net mineral acre to non-consenting owners in an integration proceeding.
No,
Is that what you're saying?
That's not what I'm saying. There
Okay.
was the most recent integration prior to this one was at 100 an acre. Prior to that, I don't think there were any integrations near that level.
Okay. In determining pricing for oil and gas leases, does your company ever rely on the extent of known oil and gas reserves? Is that part of the equation?
Ask the question again.
Sure. Let me ask it slightly differently. You've got some information from your geologist that there is likely recoverable hydrocarbons in section 24, correct?
Yes.
And in determining the value you will offer to mineral rights owners, do you consider the extent of the suspected reserves?
Yes, and the same holds true for every unit in every other state in the United States.
Okay. But the expected reserves are one of those factors that go into lease pricing. Is that correct?
Yes,
Okay. And you are not going to tell me what your expected reserves are in section 24, are you?
confidential information.
Okay. And so without that information, it's impossible to determine the fair market value of these leases, isn't it?
Every mineral owner, every owner has the right to do their own
Sir, that's not the
investigation.
question I asked.
Mr. Pietrowski,
Without that
please,
information, you have a superior bargaining position, don't you?
Mr. Pietrowski, out of courtesy, please allow Mr. Brown to answer the question.
Sir, my question in which I interrupted your answer was, without the data on the expected reserves or suspected reserves, whatever data you have about whether there's hydrocarbons under section 24, that data is relevant to determining the market value of leases in that section, correct?
Correct.
And you use that data to decide how much your company will offer for those leases, right?
Correct.
And in fact, if you had a spacing unit that you knew had, I don't know, we'll make up some hypothetical numbers, that had 3 separate reservoirs at 3 different depths, all of which you thought could be reached, and which appeared seismically to be quite large, you would offer a different price for leases in that unit than you would in a similar unit where all you knew was that there was 1 reservoir you might be able to get some gas out of.
Are we talking about the Payette Basin? Again.
I'm talking about in general.
So now we're talking about leasing in the entire country. We're not talking about lease terms in or surrounding the unit as is the factor set forth in the pre-hearing order.
The speaking
I object to
objection
the questions.
The speaking objection is designed to prevent Mr. Brown from actually having to answer the question. In fact, I am asking Mr. Brown how he sets the value of leases in his experience. That's all I'm asking him.
It's a good question, Mr. Pietrowski, and it's a good clarifying question, Mr. Christian. So now that we've resolved that, Mr. Brown, you can't answer the question.
What is the question?
The more you know about the reserves in a particular spacing unit, the better you're able to set an accurate market value for leases in that unit. Isn't that correct?
There's so many factors and so much risk, and I make educated decisions as best I can, business decisions, and it's competitive, and we negotiate with all the owners, and per the integration process, the unleased parties get the best terms that were given in the. It's a very fair process.
And when you're setting prices to negotiate, don't you rely on the knowledge you have of what you expect to be under that plot of land?
Correct.
Okay. And a person who owns 1.5 acres, they don't have the ability to determine what lies under that property, do they?
Objection calls for speculation.
Agree to sustain the objection. Mr. Pietrowski asked a different question.
Would you agree with me, sir, that negotiations would go differently if you had to share all of the information you had about expected reserves with the property owners?
Objection calls for speculation.
I would agree with that objection.
Mr. Brown, why don't you share your knowledge of expected reserves with property owners?
Objection relevance. And asked and answered. He's
Yes.
already testified it's a competitive environment.
I agree with that. And I'll also say as a hearing officer, it seems to insinuate something negative about the applicant.
Well, I wasn't insinuating, but I think you all know my opinion of the applicant as a company. It is likely, Mr. Brown, that it is possible, we'll start there, that Snake River Oil and Gas will seek to drill more than one well in Section 24, won't it?
Possible.
And the number of wells will be based in part on the number of different pools of hydrocarbons that become available through further exploration. Is that right?
Correct.
And if you had a spacing unit in which you knew right now that there were multiple pools, would the market value of leases in that spacing unit go up or down based on that knowledge of multiple pools as opposed to one pool?
Ask that question again.
Sure. As you gain more knowledge about the resources underlying a particular spacing unit, that additional knowledge can increase the market value of the mineral rights in that unit, correct?
Yeah, every oil and gas lease we buy is bought with the possibility that there will be more than one well drilled. And drilling an initial well, you learn so much. So there's so much speculation and so much risk involved that you learn by drilling.
You keep saying so much risk is involved. What's the expected failure rate for drilling wells for your company in the Payette River Valley? What percentage of your wells do you anticipate will come up dry?
Don't have a fixed.
Okay.
We're a lot of feel. We're risk takers. So that's what we do.
Okay. And you understand that a lot of suburban homeowners may not have your same tolerance for risk, right?
Objection calls for speculation.
I sustain that objection. Go ahead, Mr. Pietrowski.
The risk you take, that's part of that goes into the pricing of your leases, right?
Perceived risk, yeah. It's
Okay.
just all. Yep.
Right. And so if you perceived far less risk of having a non-producing well, if you knew that wasn't likely to happen, the value of the leases, the value of the mineral rights would increase, correct?
Yes.
Okay. You don't currently have, Snake River Oil and Gas does not currently have any existing plans to drill more than one well in Section 24, right?
Not at this time.
Okay. And so your application for integration is based on the pool of hydrocarbons that's been identified by your geologists, the ability to drill hopefully a single well to reach that pool, and your assessment of the risks and rewards involved in that prospective business plan, correct?
Objection, it misstates the contents of the application.
I would sustain this, and I also have a separate clarifying question for Mr. Pietrowski, and I mean this is a courtesy for me. If you don't mind, share with me as the hearing officer what your general line of questioning is. Why I know we've been going down this road for several minutes now, and I mean this objectively. Please share with me what your goal and theme is here as we go down this line.
Mr. Thomas, you're well aware, I think, of my clients, well, not these particular clients, but of the objections by many of my clients to the drilling of second, third, fourth, fifth wells all based on an integration application that envisioned one well. It is quite a different thing when somebody says, I want to buy from you the right to develop one well in your neighborhood and to drain one pool of hydrocarbons. It's quite a different thing to say, I want the ability to drill as many times as I want for as many hydrocarbons as I can find. That coupled with the lack of knowledge and the unequal bargaining power of the parties here is relevant to determining just and reasonable rates. You have the power to integrate only the single pool. You have the power, I believe, to integrate with an order that says SROG shall be the operator of one well, leaving the parties to negotiate over future subsequent wells when knowledge is more fully shared. What Mr. Thomas or Mr. Brown wants is to get all of the hydrocarbons now when everybody is ignorant about their existence and value. It's good business. It's not just and reasonable.
All right, thank you, Mr. Piotrowski. You did answer my question, notwithstanding the ignorant statement. I appreciate you clarifying that with me, and you can move forward, please.
Ignorance merely refers to lack of knowledge, sir. It's not intended as a derogatory term. It's meant in its precise term for lack of knowledge about a thing.
Thank you.
So, Mr. Brown, in fact, if there are multiple pools of hydrocarbons, if we knew that there were multiple pools of hydrocarbons and there was a much higher expectation of one, a return, and two, a much higher expectation for the volume of production, that would increase the value of leases in a unit, correct?
And I'm getting confused here. So you're espousing that I'm paying these unleased parties the same price I'm paying, the highest price I'm paying in the entire unit, and I'm not getting any surface use, and I'm not getting but to drill one well when every other lease I'm buying in the unit covers multiple wells. So you're telling me that that's fair, and I'm missing something here. So you're telling me I'm supposed to get an integrated lease that only covers one well, and yet I'm going to pay them the highest price I pay in the unit. I'm not going to get an option to extend. I'm not going to get surface uses. So I'm missing something here.
What you're missing, sir, is that you're the only one with the knowledge to set a fair price. And my clients are entitled to ask you questions to get the knowledge needed to also set a fair price.
So the majority of the owners in the unit are they're not reasonable folks, and they're not fair, and they're not. And
they're different folks, sir. Different folks with different goals and aspirations and priorities. And that's how markets work. And you are trying to force people to join your expedition here who don't want to. So yeah, it's not fair any more than it's fair.
I'm going to object. Is there a question there?
Under their property.
Mr. Piotrowski and Mr. Brown, again, I respect the passion both of you have on this matter. Both said your pieces now. Mr. Piotrowski, you can move forward with your next question, please.
Sir, with the current knowledge of Section 24, you have filed an integration application that is based on the only plan you have at the moment, which is to drill a single well to a particular pool of hydrocarbons, right?
Objection. It misstates the content of the application. The application clearly states that they've identified secondary objectives.
Sustained.
Okay. Mr. Brown, you filed this application knowing that you had no plans, no concrete plans for any secondary or tertiary wells, right?
Objection. Misstates. I mean, I don't understand the question. The application states they intend to explore secondary objectives pending the results from the initial well, which will bottom out deeper.
Let me ask a different question. Mr. Brown, you told me you have no plans for second or third well in this unit. Was that a lie? Is Mr. Christian saying that that's not accurate?
At this present moment, that's the question you asked, and I said, this moment right now, but I won't know. What I also told you is I said we learn by drilling. That's how we learn. And there are other objectives in the area. We found it in every unit. We learn things.
And the other side The owners of minerals, the people you are taking minerals from against their will, those
Objection
folks
to the form of the
also
question.
learn from drilling, don't they? They also learn, don't they?
Objection calls for speculation.
Again, sustained objection, Mr. Piotrowski. I believe, and if I'm wrong here, your question was that the mineral interest owners learn from drilling. Is that what you asked, Mr. Brown?
Just like the operator does. Yes, that's my question to Mr. Brown.
To the extent he's asking for the owner's state of mind, what's in their head, I object. It calls for speculation.
Mr. Brown has repeatedly stated, we base this based on what we know and we learn more as we drill. I am merely trying to get him to acknowledge the fact that the exact same thing is true for mineral owners. They learn from the experience. That's all. Is that correct or not, Mr. Brown?
Same objection.
I think I'll overrule that. I think it is a general question. Fair enough.
An oil and gas lease covers the ability to drill multiple wells. That is what we're buying here. So your clients are making a decision. They can participate. They can be declared they can go non-consent, or they can
They
be
don't
deemed
have the
lease.
option to not sell the minerals though, do they?
They're not selling
not
their
an option.
minerals.
Who has the minerals after you're done taking them out of the ground? Who has physical possession of hydrocarbons after they come out of the ground? Is it my clients?
Objection, Mr. Administrator. We're just
I want an
engaging
answer to that
in an
question, sir.
argument.
Overruled. It is a clarifying question regarding ownership of the minerals after they've been extracted. Mr. Brown can answer that question.
Objection calls for a legal conclusion.
Oh, well, regarding ownership, I think Mr. Brown is knowledgeable enough to offer an explanation of the ownership of the minerals after extraction. But thank you seriously for the caveat.
What's the question?
Who owns the gas after you extract it? And before you sell it?
Who owns the gas? So who owns the gas? Who owns the gas after it comes out of the ground before we sell it?
Yep.
Who owns the gas after it comes out of the ground before we sell it? Legal conclusions, yeah, but that would be the
Fair enough.
royalty, part of it's working interest gas, part of it's royalty.
Thank you. Good job.
But SROG sells the gas it extracts to downstream users, correct?
Correct.
Okay. And so, in fact, the lease you are trying to compel my clients to be deemed to have entered calls for the separation of all of their minerals based on only the information that is available today. Right?
They can participate.
I'm not asking about participation. I'm gonna limit my questions to leasing. They have to decide whether to enter a lease agreement based on the information that's available to them right now, right?
They don't have to lease. They can participate or they can go non-consent.
But they're deemed leased if they go non-consent.
Or
That's
if
not
they
They're
correct.
elect
leased if they don't sign a lease. Is that right?
No, he doesn't understand the terms.
You know, Mr. Christian, your snarky comments don't do a lot to help this process, but I can meet them.
Yeah.
Mr. Brown, the question is.
I'm sorry, Mr. Piotrowski, let me address something. Mr. Christian, for the sake of civility here, let's make sure that what we state is related to an objection, or if at some point you need to speak with your client, you may ask for a recess. But in general, I would like for the dialogue to continue to be between Mr. Piotrowski and Mr. Brown. I think Mr. Piotrowski may be wrapping up. I don't know. He's got whatever time he needs to move forward, but I just want to clarify that, and thank you. Mr. Piotrowski, you may continue.
Mr. Brown, as you sit here today, you have more information about the value of the hydrocarbons under my client's land than my clients do, don't you?
Probably.
And that information comes in part from seismic studies you've performed and other work that you've had done. I don't even understand it all, don't pretend to, but other work you've had done by geologists, right?
Yes.
Okay. And that is information that Snake River Oil and Gas owns, in the sense that you paid for the studies or your predecessor paid for the studies, and you could share that information if you wanted to, right?
Yes.
Okay. And you've shared that information to the extent you felt it was necessary to support the integration application in this case, right?
Yes.
Okay. But there is more information that would shed additional light on the value of the minerals in section 24, isn't there?
You talking about proprietary business information?
Yeah, I'm saying there's additional information you have, which you have not been obligated to disclose, that would provide, for somebody trying to value these minerals, you have information that would be useful for that valuation that you have not chosen to disclose because it's confidential business information, right?
Because I'm in a business
Sure.
and a competitive business.
Okay.
Okay.
But there is additional information, right?
Yes.
Okay. And you are legally entitled, if you wanted to, you are legally entitled to share that information. There's nothing stopping you from sharing that information other than the competitive environment, is there?
Except I would be breaching all kinds of obligations with my partners and
But there's no legal impediment. You haven't signed a non-disclosure agreement. Your geologists do not tell you what you can and cannot share, do anything like that.
There are seismic agreements. Yeah, I would have to be very careful.
Okay. And all of that information is relevant, isn't it, to determining the value of leases in this section?
Objection asked and answered.
Sustained. Thank you.
I'm sorry, sir. Is it sustained because you think I did ask and get an answer to that question already?
It's sustained because it was asked and answered, and it's also a question that you've already asked probably a few times so far.
Have you done any workup on anticipated expenses for section 24?
What's the question again?
Have you, and by you, I mean Snake River Oil and Gas and its employees and officers, have you done any work to determine, I'm sorry, I've lost track of my own question, sir, so I think it's best if I just move on, and I will do so. Have you ever entered into a lease in the Payette Valley that explicitly called for only one well?
Don't think so.
Okay. The leases you have with voluntary leases with mineral owners in the Payette Valley, those are not confidential, are they?
Lease terms often are.
Does Snake River Oil and Gas file its leases with county recorders?
Some. Some yes, some no.
Okay. And those that you do file, those are not confidential, are they?
That's correct.
Okay. What percentage of your leases are subject to some kind of confidentiality that would prevent you from recording them?
Sometimes the landowner won't want them recorded.
Oh, I understand. I wasn't asking for the reasons. I was asking what percentage do you not record because for some reason or another, somebody wants it confidential?
I can't, maybe 15, 20%.
Okay.
I don't know. I don't,
I'll take that at the face value that it's a best estimate and nothing more.
that's correct.
Okay. Are any of the records, I'm sorry, let me just ask a few questions to get to the point here. You maintain business records for the activities of Snake River Oil and Gas, right?
Correct.
And it would be possible, if you wanted, to look at any particular drilling operation, any well operation, and determine the costs that went into that particular process, right?
After the fact, yes.
Right. And that information about what things have cost you in this basin in the past, does that help inform you in making your estimates of anticipated future costs?
Correct.
Okay. And I know these seem like silly questions. I'm really just trying to confirm. You rely on your experience in this basin to help set prices in this basin, right?
Yes.
Okay. So just to clarify, the proposal for the terms under which people will be deemed leased if they don't choose to either enter a lease or become a working interest owner of one kind or another, the terms you've proposed are a 1/8 royalty, $100 per net mineral acre, no surface access. And what other things do you think are the critical terms that you would want homeowners, mineral owners to be aware of?
That's
Okay. And those terms which I realize are not all the terms by any means, but those three terms I laid out, those are the terms that the company is proposing in this case, right?
yes.
Okay. Thank you. No further questions.
Thank you, Mr. Piotrowski. Before I move on, I got a couple of questions that I'd like to add. One question. And then I actually have another question to ask you, Mr. Piotrowski. Mr. Brown, you're a landman, correct?
Correct.
Basically. And my question, again, state geologist here, but I'm not that familiar with county rules. Would you mind sharing what sort of conditions a lease would be submitted to the county or not submitted?
You're breaking up just a hair. Can you say it again?
Yeah, Mr. Brown, could you share why a lease would be submitted to the county versus why it wouldn't be?
To the county?
Well, we talked earlier about leases on record with the county, and you indicated that 15% of them might be. Can you share?
For recordation?
Yes.
Well, some larger landowners prefer their business not to be out in the public record. That's one example. So oftentimes, if a lease is not recorded, what's recorded is a memorandum of lease, which puts people on record. And I'm not a lawyer, but I know a little bit about land law. If somebody goes and sells a second lease and you don't have a memo or a lease recorded, then there's no notice. And even though the land, so somebody sold a second lease So that's the main purpose of recordation, is to put folks on record. So you can either put a memorandum of record or the actual lease of record. But most generic landowners, I'm going to say, like I say, probably 80% of our, that's a pure guess, but 80% of our leases, both on the Oregon and the Idaho side, are of record in the county courthouse. Did I
Thank
answer
you.
your question?
Yeah, thank you, Mr. Brown. And a clarifying question to Mr. Piotrowski. Some minutes ago, on my end, you inferred that a lease, pardon me, an application or an integration application involving some of your clients, that they would feel differently about one well versus multiple wells, you know, extracting their mineral resources. That intrigued me. Can you clarify that? Do you have clients that would be okay with one well that wouldn't be okay with multiple wells, or do you know? You're muted.
Yes, all of my clients in the Barlow litigation, sir. They were all okay with one well. When it became 4, we litigated. We lost, unfortunately, but yes, it's clearly evidence that some people treat one well as different than 4 wells or 3 wells or 8 wells.
So clarify. Good. I think I asked my question a little bit too broadly. Regarding this integration, do you know if some of your clients would be okay with one well versus multiple wells?
I know that several of my clients are concerned about what they saw in the Barlow, that the difference between one well and multiple wells is significant, and their concerns in general include the number of wells. Now, I'm not saying they'd suddenly be willing to sign a lease, but we're not here to get them to sign a lease. We're here to set just and reasonable terms. And it is more just and more reasonable in their perspective if you order that SROG has the right to drill a single well. That this integration covers the pool they've identified.
Thank you, Mr. Piotrowski. And for clarity, we've already established just and reasonable in our prior hearing. This hearing is about the evidentiary.
This hearing is about whether the terms proposed are in fact just and reasonable, I thought. I mean, if there is no set of circumstances in which I can convince you that the proposed terms are not just or reasonable, then we really are wasting our time and you should just let us know.
Yeah, clarity. I think we're nuances here, and I shouldn't have said nuances, but I've already issued an order talking about what just and reasonable is, and so now we are talking about the integration of the unit. So I think we're on the same page here. I just want to make sure that I understood what you were saying, that we weren't rehashing a prior hearing that's already been resolved.
Sir, I am not at this point attempting to get you to revisit the factors you said you would weigh. I am presenting evidence that I think is relevant to those factors, including evidence that they built a business plan on one well, but they're insisting on all the wells. And I don't think that's just or reasonable.
I appreciate that. Thank you, Mr. Piotrowski. So with that, I go to the department. Ms. Winter, do you have any questions of this witness?
No, Mr. Hearing Officer.
Thank you. Does Snake River, Mr. Christian, does Snake River have any redirect for this witness? You're muted, sir.
Thank you. Sorry. Yes, I would like to state initially, though, an objection for the record. To the extent Mr. Piotrowski's comments are intended to state his client's intentions or concerns, of course, attorney comment is not testimony or evidence, and so I want to make that clear for the record.
Thank you. Fair enough.
Okay, Mr. Brown. I'll try to keep this brief. You are by education and experience trained as a petroleum landman, is that correct?
Correct.
And how many years have you been engaged in that pursuit?
40 plus.
And how many states would you say you've worked in?
10.
And rough estimate, could you could you hazard a guess or an estimate about how many integration or pooling applications or proceedings you've been involved in, either as an operator or otherwise as a working interest partner?
Well over 200, 300, possibly as many as 500.
Okay. You answered in response to Mr. Piotrowski's question that about 80 to 85% of the leases that Snake River holds are recorded. You recall that?
Yes.
Okay. And would it be possible for any landowner, should they wish, to either go to the county recorder's office or get on the county recorder's website and obtain copies of whatever leases they wanted to find?
Yes.
Likewise, Snake River files regular production reports with the department reflecting production from wells. Is that right?
Correct.
Also, and yes, and it also files with the department reports of the drilling and completion and testing of wells, right?
Correct.
Okay, and all of those records are publicly available.
Correct.
So to the point of Mr. Piotrowski's question, there's at least some information that landowners could obtain readily, either from the county recorder's office or from the department's own website.
Correct.
You may have answered this question already, but have any of the voluntary leases that Snake River has taken or holds, are any of them limited by depth or formation?
I don't think we have one lease in the entire basin that is limited by depth.
Okay, so the imposition of an order limiting, at least in this case, by depth or formation would be more favorable than the terms of that term as to any other lease that Snake River's taken in the basin.
Absolutely, and limiting it to not provide for multiple wells would be different than any other lease in the basin, and would also be different than any other state in the United States.
Well, let me go to that question. Have you, in the poolings that you have been, or integration proceedings that you participated in elsewhere, except to the extent an operator is specifically targeting only a one formation and asks for it, has it been a regular practice in your experience for the form of lease or deemed lease option to be depth or formation limited?
Absolutely not.
Mr. Piotrowski asked you a question about an AFE and whether you had prepared, whether an AFE for a well in section 24 existed. Do you recall those questions?
I did. Yeah, and
Okay.
I used the word AFE. Yeah. Yep.
Okay. Would it ever be your normal practice to prepare an AFE for a well prior to the spacing and integration of a unit being completed?
That it would all depend. It could or could not. It's not unique. We do cost estimates throughout the process.
Okay.
And depends, and costs depend on market conditions, and they vary. If you wait 3 months, the AFE might move.
Okay. There were some questions about reserves and whether you would disclose reserves to either as part of this process or in the leasing process. Do you recall those questions?
Yes.
Okay. In any other pooling or integration proceeding you have participated in over your years as a petroleum landman or as a working interest partner, has a component of it ever been disclosure by the operator of anticipated reserves?
Not that I ever recall.
Okay, and likewise, in all of the other integration or pooling proceedings you participated in over the last 40 years, has it ever been a component of that proceeding that you would be required to disclose your expected return on investment?
Not that I recall.
There was a question, well, following up on that. In your experience over the last 40 years as a landman, is it ever the case that the operator pursuing a lease discloses reserve and cost and revenue information to a landowner as part of the lease negotiation process?
In negotiations, you could talk about some, very rarely a landowner might want to talk about participating in some form or fashion. And then that conversation would come up. And in this instance, of course, they have the right to participate. And so to ask your question again.
Well, the question is it a normal part of the lease negotiation process for you to lay out all your cards on the table and disclose to the landowner all of your information about reserves and potential revenue?
Not reserve discussion, no.
Okay. There were some questions about dry wells and risk. Is it the case that all of the wells that either Snake River has drilled or Alta Mesa, the prior operator, drilled, that they were uniformly productive?
No.
There's been quite a bit of variability in the productivity of the wells that have been drilled.
Correct.
And in fact, some wells have been either unproductive entirely or have not produced to the level that would allow you to recover your investment, right?
Correct.
Do you think that condition remains in the unit, or you're in other words, you're still learning?
That is correct.
Okay. In your experience in pooling or integration proceedings in other states, do the holdouts, the objecting mineral owners whose interest is integrated, do they ever get a better deal than those who voluntarily leased in the unit?
No.
Do you know whether any of Mr. Piotrowski's clients in this proceeding responded to any of Snake River's leasing efforts?
My recollection is one or two responded initially, and then most were just did not ever respond or just had no interest whatsoever in an oil and gas lease and asked us not to knock on their door, not to call them again.
In other words, they didn't indicate any interest in negotiating a lease.
Correct.
Last couple of questions, Mr. Brown. Back when Snake River initially became a working interest partner in this basin, first of all, Snake River was a working interest partner under the prior operator, right?
Correct.
Okay. And at the time that you first became involved, which was that about, let's say, a dozen years ago?
Correct.
What were the royalty rates that were being offered and paid for voluntary leases? I'm sorry, not royalty rates, the bonus rates that were being offered and paid for leases at that time?
$3 to $5 an acre.
And did they eventually progress to a higher number?
Yes,
Okay. So at least in the dozen years that you've been here, the bonus rates have increased 20-fold from where you started, right?
correct.
Okay.
And there, 1,000 leases taken, 1,000+ leases taken in the basin. My guess that less than 1%, I'm gonna say I recall fewer than 10 leases with greater than an eighth royalty, right, somewhere between 8 and 10 out of 1,000. So I'm gonna say around 1% or less have royalty greater than an eighth.
Would those typically involve large landowners
Typically,
because they have buying power, because they can offer you a significant amount of acreage in a unit?
correct.
Okay. I don't think I have any other questions for you. Thank you.
Thank you, Mr. Christian. Thank you, Mr. Brown. Mr. Christian, you may call your next witness if you have any.
We have no other witnesses, Mr. Administrator.
Mr. Piotrowski, if you have any witnesses, you may call them at this time. And you're muted.
We've been at this for a couple hours now. I'd like to ask for a break before I make any decisions that might be influenced by the needs of my body.
I understand. We concur. How about 10 minutes, folks? Will that be okay?
That would be perfect. Thank you.
10-minute recess. Thank you, gentlemen and ladies. Getting close to the end of the recess, folks. Is everyone back? I see. Good, excellent, very good. Mr. Brown is reconnecting. Mr. Tom is on. All right. So where we left off, I had asked Mr. Piotrowski to call non-consenting owners first witness.
Thank you. We'd like to call James Thumb.
All right. Mr. Thumb, give you the oath here. Do you swear or affirm that the testimony you will give at this hearing is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Piotrowski. You may proceed.
Thank you, Mr. Thumb. How are you presently employed?
I'm employed by State of Idaho, Idaho Department of Lands.
What do you do there?
I am a program specialist in the minerals division for mostly oil and gas.
And are you the person to whom integration applications are initially forwarded for evaluation by the Department of Lands?
Yes, they are submitted to me.
Okay. What is your role at that point when you receive a new integration application for oil and gas?
Based on the application requirements of the statute, I make sure that the application fulfills those requirements and accept it for the department.
And what exactly do you do to ensure that the application fulfills the legal requirements?
I compare what is submitted to what is required in the statute, and if everything is there, then I say that's okay to go ahead.
Okay. The statute includes a list of items that must be included in any application. Is that the list you use, basically the one straight from the statute?
That is correct.
Okay. And do you evaluate whether the applicant has indeed obtained the appropriate percentage of voluntary leases from landowners in the unit?
Can you restate that, please?
Sure. Among the requirements with an integration application is the requirement that the applicant must show that a certain percentage of mineral owners has consented to the development of the resource in that unit. Do you confirm that submission has been made?
That is confirmed by an affidavit that is also filed by the applicant at the time.
Okay. Other than the affidavit, what other materials do you rely on to make the determination as to whether an appropriate percentage of mineral owners have joined or have leased?
We do not make any other determination unless a landowner who possibly was stated as leased in the application came forward and told us that that was incorrect. We do not make any other assertions.
Okay. Does the department receive copies of the leases as part of the integration application?
Never.
Okay. Unless somebody explicitly calls into question the information contained in the application, is there any circumstance in which the department takes further steps to verify the percentage leased?
No, other than to look at the resume of efforts, look at the lease totals reported by the applicant, compare them to the map. We make no other determinations.
Okay, thank you. That's all the questions I have. Oh, now you're muted, Mr. Thomas.
Keep each other lined out here. Thank you all. Go through here. You have no other witnesses that you're going to request. So I will move to the department, Ms. Winters, and you may call your first witness.
We have no witnesses. Thank you.
Much. At this time, I'm going to allow the parties to offer closing arguments. I am going to limit closing arguments to 20 minutes. I believe it should be done sooner than that, but there is those are the sideboards. And in the order for closing arguments, it's going to go operator, Snake River, and then Mr. Piotrowski, Ms. Winters, and then Snake River may offer any rebuttal. So at that time, or at this time, Snake River, you may make any closing arguments.
Thank you, Mr. Administrator. As Mr. Brown testified, and as is reflected in exhibits, I believe SR 2 and 3, about 88% of the net mineral acres in Section 24 are committed to development by voluntary leasing. The applicant has supplied both as with its application, the material submitted in support of it, the declarations and exhibits, and through the testimony of Mr. Brown today, sufficient information to entitle the applicant to an integration order, and I would submit to allow you to apply the just and reasonable factors and issue an integration order on the terms requested by the applicant. To some of the issues that have been raised by Mr. Piotrowski on behalf of his clients, the vast majority of leases in this case are a public record, as are production records and drilling and completion records for wells in the area, and are available to not only mineral interest owners, but anybody else who wants to look at them. Mr. Piotrowski and his clients could have obtained any number of leases or other records going to the issues that he's argued about here today, but they have not done so. Mr. Piotrowski's could have presented witnesses, including his clients or others, to provide testimony or other evidence to challenge any part of the application or supporting materials. They have not done so. As near as I can tell, there is no issue, been no material issue raised regarding the statutory requirements, such as the likely presence of hydrocarbons, the resume of effort sufficiency, the percent leased, or pre-hearing notice issues. So it appears to me that what we are left with is a discussion of just and reasonable terms of integration. Outside of some discussion of risk penalty in Mr. Piotrowski's questions, I don't believe there's been any issue raised regarding the terms of the proposed JOA. Outside of some discussion of lease bonus and royalty, I don't believe there's been any issue raised regarding other proposed lease terms. I would suggest that discussions of leases in far-flung areas are not particularly relevant to just and reasonable terms in this instance. There's been abundant testimony that the market in this area, for the reasons Mr. Brown described and that are described in the application, is and has been, as is requested in the application. As you know, the relevant point in time under the statute for determining lease bonus and royalty for purposes of leased and deemed lease status is as of the time of the application. It may very well be that we are back in front of you in a future proceeding where we are asking for integration on terms that are different than those because of ongoing leasing in another unit. But as Mr. Brown testified and as is set forth in the application materials, the vast majority of leases in this unit, and I believe all of them prior to the time of application, were at $100 and an eighth. As I think we've discussed in prior proceedings, Mr. Piotrowski's view is that just and reasonable means that his clients get the best deal of any landowners in a unit. In other words, that they are incentivized to hold out. And I would submit to you that that is not the purpose of the integration statute, nor is that a just and reasonable result. The statute, as we know, provides as the mission for the department and the commission a few things: to encourage production, to protect correlative rights, and to prevent waste. And by insisting that those people who hold out, who refuse to negotiate to the end, receive the best deal of anyone in the unit, the result of that is that the correlative rights of everyone else in the unit are injured. For example, if the holdouts are awarded a higher royalty than anyone else in the unit, they get a larger piece of the pie just by virtue of math if there is a productive well established, which is injury to the correlative rights of other royalty interest owners or the working interest owners in the unit. So for those reasons, I suggest to you that the order requested by Snake River is appropriate. It is supported by the application materials and the testimony provided, and the terms and conditions that are requested are just and reasonable. Some of the issues that are raised by Mr. Piotrowski, I think Mr. Brown pretty firmly established, are not issues that are addressed in virtually any other integration or pooling proceeding anywhere else in the country, and are not relevant. So we'd request that the order be issued on the terms requested in the application. Thank you.
Thank you, Mr. Christian. Next up, Mr. Piotrowski, you may make a closing argument at this time.
Thank you, Mr. Thomas. Fact of the matter is, as Mr. Brown clearly testified, Idaho gives its property owners a better deal than other states. He's never had to pay more than an eighth in another state, yet he's had to in Idaho. He's never had to give up surface rights in another state, yet he has had to in Idaho. In fact, that is because Idaho is not other states. And yes, my clients do get the best deal by holding out, because that is 100% consistent with the statutory directive. As Mr. Christian was just saying, the statute calls for the encouragement of production. Well, you know what? Paying a fair market value to the owners of a commodity encourages them to sell that commodity. That is how America works. If you want to encourage production, then you raise the price you pay to the people who can make production happen. In this case, that's mineral owners. If you want to produce their minerals, pay them better. It's not complicated. If you want to protect people's correlative rights, well, the correlative rights Mr. Christian is talking about are the people who sold their minerals early and possibly cheap. But that was their right. Their right was to enter into a lease if they wanted to, and not if they didn't. And if they chose to enter into a lease, then the fact that my client gets a better lease doesn't change the value of their lease at all. So paying my clients more than other property owners doesn't interfere with, harm, in any way affect correlative rights. In fact, if an early lessor wants to make sure the well gets drilled and goes into production, then that early signer should be encouraging Snake River Oil and Gas to pay whatever it takes to get the holdouts on board. That is how market economies work. And Mr. Christian here and Snake River Oil and Gas don't like the way market economies work, because what they do is they give more power to those who value their resources more highly. Finally, paying my clients more avoids waste. When Snake River can buy mineral rights for a pittance, the way they've done in Idaho for over a decade now, they don't value what they have bought, or rather, they value it just as much as the lease tells them to. And so a lease that puts a higher price, whether that price is through the bonus payment, through the royalty rate, or through other terms and conditions, a lease that is more expensive forces Snake River Oil and Gas to put more value on the oil and gas they can recover, and therefore encourages the avoidance of waste. These are terms that the statute includes and that the industry wants to have you interpret a certain way, which is not necessarily consistent with the plain meaning of those words. You avoid waste by pricing something appropriately high. If you undervalue it, it will get wasted. Now, this is why, all of these factors are why in Idaho, the holdouts do get a better deal. Mr. Brown just testified all of these things he's never had to do until he came to Idaho, and now he has to do them. And how has Idaho made that happen? Because property owners have resisted his attempt to develop the mineral fields as cheaply as he possibly can in order to maximize his own profits. And he doesn't do that to protect correlative rights. He doesn't do it to avoid waste or to encourage production. He does it for a profit because it's a market economy. So let's get over the idea that my clients are somehow stuck with the bad deal that somebody else made, because that's not right. That's not American, and that is not what the statute calls for. Now, you're right, or Mr. Christian was right. We haven't put on much evidence. But that's because my clients are not asking you, Mr. Thomas, to do anything. We would prefer that you do nothing. We don't want the Department of Lands to do anything. Not on this application. We don't have a burden of proof because we are not asking for any action to be taken. And so the burden of proof lies with Snake River Oil and Gas, as you have expressly determined and found, Mr. Thomas. So let's talk about whether or not Snake River Oil and Gas has carried its burden of proof. Now, the evidence in this case is extremely limited. Almost all of it would, under the rules of evidence, amount to hearsay. Mr. Brown did not go out and negotiate the leases in Section 24 himself. Not all of them. He may have done some of them. Mr. Brown did not go out and determine what each property owner was going to get or what each property owner was going to demand. He had landmen to do that. We had Mr. Boney submit an affidavit, but an affidavit is hearsay. It's an out-of-court statement. We had Mr. Smith submit an affidavit, but an affidavit is hearsay. Now, here's the hearsay rule doesn't apply to this proceeding. And so we didn't object to all this hearsay going into the record. We mention it now for a different reason. Well-established law in Idaho, findings made by the Idaho Supreme Court have held for many years that an administrative process may not base its findings of fact solely on hearsay. And yet none of the evidence in front of you is anything but hearsay. You do not have the evidence necessary to order integration in this case, because Snake River Oil and Gas has not met its burden of providing you non-hearsay evidence about just and reasonable terms. They haven't presented you any non-hearsay evidence about whether they actually have leases. We have an affidavit to that effect, and that's about it. So as a matter of Idaho law, if you issue a decision approving this application, Mr. Thomas, you will necessarily have to do so purely on the basis of hearsay evidence in violation of Idaho law. To the extent you choose to do so anyway, I would suggest that you don't have reliable evidence either to determine the actual just and reasonable price for deemed leased individuals in this circumstance. You don't know that 1/8 is a real market price because the only evidence you have on that is hearsay. You also don't have the best evidence on that topic. Mr. Brown can come in here and testify all he wants, but the best evidence of what leases do, what terms leases in this market include, are the leases themselves. And Snake River Oil and Gas hasn't chosen to provide that to you. They don't submit any of their leases. They don't submit them to Mr. Thumb, and they haven't submitted them to you, Mr. Thomas. In terms of what's reasonable, what's the market rate, or what's the industry standard, the only evidence we have of that is the hearsay from Mr. Brown. We know for a fact that indeed he has paid more than an eighth on at least one lease. In fact, he admitted he has paid more than an eighth on multiple leases in the Payette River Valley. And there is no way for non-consenting owners to double check any of that, because Mr. Brown only records the leases he wants to record. Even in his estimate, 15 or 20% of them aren't recorded. And so we could never learn how many leases are for over an eighth, how many leases are for over $100 bonus payment, how many leases include other more favorable terms for mineral owners. Snake River can't prove that because they haven't chosen to bring you the leases. We tried to disprove it, but you wouldn't give us a subpoena for those leases. And we have no way to get them other than through subpoena. We can get 80% of them, but 80% is not all the leases. And we don't know which ones Mr. Brown chooses not to record. So what we are left with is an entirely hearsay procedure that doesn't determine the fair market value of these leases, that doesn't determine whether 1/8 is just or reasonable. All you have is evidence to determine that that is the rate Richard Brown would prefer. He would prefer to pay 1/8 at $100 an acre. His preference does not prove what is just and reasonable. And Snake River Oil and Gas has entirely failed to prove that their proposal here is a just and reasonable one. And as a result, the application should be denied. Thank you.
Mr. Piotrowski. Ms. Winters, you may make a closing argument.
We have no closing argument, Mr. Hearing Officer. Thank you.
Thank you. Snake River may provide any rebuttal at this time.
I have nothing further, Mr. Hearing Officer.
Thank you. And thank you all sincerely for participating. I will take the matter under advisement and issue a written decision within 30 calendar days of this hearing. That, and remember, as I want to make sure what that date is, the record will be open until the close of business on the 6th. So moving forward, let's see here. Should have had this ready. That will be November 24th. Yeah, that's the Friday after Thanksgiving. Let's go for November 27th, the Monday after Thanksgiving in light of the holidays, when I will issue a written notice. That adjourns our hearing, and I thank you all for participating today.
Thank you.
Thank you, Mr. Hearing Officer.